And
That's quite all right.
we'll be live shortly.
Great.
I think we're live
You
now.
are now. All right, good morning. We apologize for being a little bit late. We were transferring between links on Zoom, and many of our witnesses were given the wrong link. And so those technical difficulties have cost us a few minutes, but we're lucky that everybody is back and that we're ready to go live. We're dealing with H-183, an act relating to sexual violence. The committee has been working very hard on changes to it, and we'll hear from Michelle, but we also asked Kate Brayton from the Victim Services Director of the Vermont State Police Major Crime Unit to discuss this bill, and turn it over to you, Kate. We look forward to hearing your testimony.
Thank you, Chairman Sears, for inviting me to testify today, and thank you and hello to the rest of the community members. Good morning. My name is Kate Searles Brayton. I'm a licensed clinical social worker in the state of Vermont, and in my social work career, I've worked with hundreds of sexual assault victims in different capacities. Currently, I'm the Victim Services Director for the Vermont State Police, and I'm assigned to the Major Crime Unit. In my daily job, I work with families who are experiencing acute trauma from the loss of a loved one through homicide or other traumatic death during the investigation phase of their case. My other responsibilities include consulting on cases statewide that include acute trauma or victimization. I'm part of the internal domestic violence task force for the Vermont State Police, as well as Vermont's Domestic Violence Fatality Review Committee. In my spare time, I teach at Norwich, and I teach victimology, victim services, and restorative justice. Just for a little background. I'm here today to talk about how trauma responses can substantially impair the ability of someone to react during a sexual assault, regardless of other contributing factors. When a person is faced with an instance of perceived danger or fear, our bodies respond with mechanisms that originate deep within our brain and affect our whole body. These reactions are involuntary, meaning they happen to you and not because of a decision-making process. I would expect that most of you have heard of a couple of the defense mechanisms. Fight, flight, and freeze are ones that often people refer to and have some common knowledge about. They're part of a defense mechanism called a defense cascade. And so there are 6 specific defense cascade reactions that can happen. I'm going to talk about a couple that we don't hear about as much. The first response is arousal. And when we experience arousal, what happens is our body opens up our senses to take in data, to start to look at potential threats around us. So all of our body systems get heightened. What usually follows is freeze. And freeze is when we stop and scan our environment and start to detect threat. And you can see this in animals and in humans. You only have to open your door to look at rabbits and squirrels in your yard to see how they react to you. When you open the door, you see that freeze happen, and they're scanning their environment to decide how big the threat is or how big of a threat you might be. I also see it often in my dogs in daily behavior. If there's a knock on the door, they'll freeze and scan before they decide what to do next. And freezing can take just a couple of seconds before you move into the next phase. And usually the next phase is that fight or flight phase, where you take action or you retreat depending on your ability to do so. And so that's the one that people know most about. But if you're in the freeze response where you're scanning and assessing and your brain assesses that there is no way to escape or there is no way to fight, your body can quickly go into what's called tonic immobility. And tonic immobility is a defense mechanism that gets triggered in humans and animals when they have the perception of being caught and not being able to escape, right? So tonic immobility is a state of involuntary paralysis in which a person cannot move and cannot speak. In animals, we refer to it as feigning dead or feigning death. In sexual assault, it's referred to sometimes as rape-induced paralysis. The reaction happens for two primary reasons biologically. One is to deactivate the kill reflex in the predator, and two is to try to avoid consumption. It's truly a last resort mechanism to preserve life, and that's its function. In this reaction, the person is aware of everything going on around them. They are aware of what's happening, but they are unable to access their motor systems, including speech. In a 2007 study from Stockholm, Sweden, about tonic immobility, they found that of the participants who had survived a sexual assault, 70% experienced significant tonic immobility in that study. It's important to understand that tonic immobility in and of itself is terrifying, because while in the middle of an assault, you're unable to engage your body and unable to verbalize. And it can have long-term impacts on mental health. People who experience tonic immobility during a sexual assault are twice as likely to experience post-traumatic stress disorder and 3 times more likely to experience severe depression in the months after the assault. People with a previous history of sexual assault are twice as likely to experience tonic immobility during a subsequent assault. And people who experience violence or penetration during an assault are also twice as likely to exhibit these symptoms. According to an article in Scientific American that looked at the research regarding tonic immobility, part of the reason for increased adverse mental health outcomes for survivors may be how we understand and judge involuntary reactions that we have perceived to in some way to be voluntary. During an assault, when the body is doing exactly what it needs to do to survive, victims are judged for not doing enough, not fighting back, or not saying no. The lack of awareness and understanding in the public on this topic, mixed with the possible shame and self-doubt experienced by victims of sexual assault, leads to a misunderstanding of the strength that it took for a person to endure the assault and survive it. Court systems can reinforce this harm by failing to recognize innate biological responses to serious incidents. Along with tonic immobility, one of the defense mechanisms past that is collapsed immobility. And collapsed immobility uses the same biological defense mechanisms as tonic immobility, except that you are rendered unconscious or semi-conscious. So the difference between the two is awareness and memory retention, which happens much more significantly in tonic immobility than collapsed immobility. In H183, lack of verbal and physical consent is not only inhibited by outside factors that you've discussed in previous testimony, like alcohol, medication, or substances, or another barrier. It can actually be our own biological defenses reacting to keep us alive that impedes our ability to resist an assault. Legislation like 183 allows for these natural, involuntary, and many times life-preserving mechanisms, and it's important for victims who are seeking safety and justice and validation of their experience. The acknowledgement of affirmative consent in this bill is a way to validate the survivors of sexual assault did exactly what they needed to do to get through a life-threatening or violating event. The language proposed in this bill regarding consent allows for the concept that silence doesn't equal consent. It allows for the possibility that the defense cascade immobility would cause serious impairment for a victim of sexual assault. When someone experiences immobility related to defense mechanism, engagement becomes impossible, consent becomes impossible, and fight and flight become impossible in those moments. There's one part of the bill in particular in the definition section under the definition of sexual assault that says, when the person knows or reasonably should know that the other person is asleep, unconscious, or otherwise unaware that the sexual act is occurring. I might be so bold as to suggest adding to that something like unable to engage in order to capture these reactions as they happen. So it would read something like, when a person knows or reasonably should know that the other person is asleep, unconscious, unable to engage in, or otherwise unaware that the sexual act is occurring. That may better include the trauma responses I talked about today. I have to say that I really appreciate the leadership of this committee to work towards more effective laws and language that truly speaks to the research in regards to trauma and violent crime. I'm also, as an adjunct professor, excited about the provisions regarding higher ed resources to focus on this as an issue. And I'm happy to respond to any questions or talk a little more about any of the things I've talked about today.
Thank you very much, Kate. I think your explanations are, it's like a college lecture, I might say, and it's something I think we don't usually get, but we can certainly use to help better understand what victims may be going through. I do appreciate your suggestion for unable to engage in, but I'm wondering what if other states have used similar language. A number of us are concerned about the draft here, and to make sure that the totality of the circumstances are taken into account and using more of the federal definition. So I'm curious if other states have used the unable to engage in, or is this?
I don't know the answer.
Yeah,
I don't know the answer to that question.
But certainly, thank you. Other questions for Kate? Senator Benning.
Kate, this just seems to be my week for looking at things in a different way and sounding like I'm a Neanderthal, but I'm going to take this shot. The one thing that has me concerned here is the concept that a long-standing married couple may be in bed together, and one partner is interested in having sexual relations with the other partner, and the other partner is asleep at that moment. And the hope is that if there is an advance of some kind, the other partner will wake up and be willing.
Mm-hmm.
As I read this bill with that language, we're creating a crime out of that situation. Am I misreading something, or is that what you nevertheless would prefer to be the case, that we are creating a crime out of that event?
I would argue that the moment that person wakes up and begins to engage in with their partner, that becomes a moot point. It's the engagement.
I would agree there, but I'm looking at the language and I'm thinking to myself, the initial move is now being made a crime. And it could just be me, it could just be the way I'm reading it as a defense attorney. That wouldn't surprise me this week especially, but I'm thinking there's just something to leave me uncomfortable there.
Let me just add a little bit about tonic immobility in the study in Stockholm, which was a nice study because it captured victims' assessments early after the assault, and not a lot of the research on tonic immobility is looking at past experiences, especially with childhood sexual assault, which is tonic immobility has very high incidence in. They use a tonic immobility diagnostic tool in order to assess the level of tonic immobility and collapsed immobility in clients. And there are a series of things that they assess. And so tonic immobility, if I could just, so if you're experiencing tonic immobility and somebody were to move your arm, they could just lift it and it would drop, right? You don't have the ability to kind of manage those motor skills, which looks very different, and I would expect should be a reasonable assessment that somebody who is trying to engage in sex with you would have, that your body is not mobile and you are not using motor skills at that time, if that makes sense. Whereas the situation you're talking about in a married couple who engages in sex, as one of them awakes, it has full function of their body and their speech usually at that time, because the mechanism is triggered only when fight and flight is seen to be impossible. It is the final and last resort.
I guess I'm not sure it's clearing my hurdle, and that's what I mean, the sleeping person could very well say, no, I'm not interested. And contact should stop. I have no question about that. But we seem to be one step before that decision being made by labeling a sleeping or unconscious person as someone who cannot consent. I guess I'll wait to hear from the Attorney General's office and the state's attorneys and the defense counsel to see if I'm missing something. Could just be me. I could be missing something, but that's what I'm fearing right now.
Could I
Philip,
just-
you are muted.
Oh, I'm muted because my entire file system. I'm muted? I should-
No, Philip was.
I
Oh,
was.
I'm sorry. You had the question. I was explaining that my entire file system here at the house just fell over, and so unfortunately, I thought I was muted, but it was Philip who was muted. So go ahead, Philip. You have a question.
I just wanted to
Senator
tag on
Baruch.
to what,
I'm sorry, Senator Baruch. Yeah, please.
okay. I just wanted to tag on to what Joe was saying. It has seemed to me, the more we discuss this, that it really, even though the bill doesn't say it, it really is creating a standard where you need a vocal expression of consent. And if you don't, and I wanted to ask you, Ms. Brayton, is that how you see it?
I don't see it as specifically always having to be vocal, but the resistance to engage in, I believe, is a lack of consent. So, for instance, if
Well,
somebody,
but let's stay on the consent side, because
Yeah.
the bill is defining everything as what doesn't count as
Right.
consent.
right,
So when you talk about resistance, so we're saying that if someone is asleep or unconscious or frozen, that's not consent. And so there has to be some active expression of consent. And I understand what you're saying, that it could be nonverbal, but it seems as though under this framing, the absolute safest thing for everyone within the law is to get an expression of verbal consent, since anything else could be read or misread in the moment. And I know that that's a fine line that the drafters of the bill were trying to walk, because there has been in other states like California, there's been pushback against the idea that there would be express consent,
right,
not just for the act, but at each stage of the act.
Right.
So I'm wondering how much you can help us with what does this bill require in terms of having something count as consent?
Yes, and you know, to be honest, most of my work is in the field, and it's, you know, so I don't often engage in policy discussions at this level. But my opinion is that verbal consent is the best case scenario. It is a clear indicator of engagement. Engagement can happen non-verbally, and I think it is hard to pin down. You know it when you know it, and so but verbal engagement, I think, or verbal consent, is the clearest and easiest to define, I believe, in consent. It is best practice.
Okay, so that's my real my real thing that I'm thinking through here is it's very clear on what doesn't count as consent, clearer than our laws are now. That's good. But there's a one sentence, I don't know if you have the legislation in front of
Mhm.
you? Okay, so there's a one sentence thing at the beginning that says consent means words or action by a person indicating a knowing and voluntary agreement to engage in a sexual act. And words obviously would be clear. Actions, again, less so. But I think what Joe is talking about is that same area where if it comes down to actions, it seems to me that's where the real genuine possibility of misunderstanding comes in. Um, you know, if someone squeezes your hand tightly, does that mean that they want it to go forward or they don't want it to go forward? So that's why I pose the question to you as somebody who is familiar with that tonic immobility. Um, isn't it the case that you might have some reactions that could be misread physical reactions?
That's a great question. With tonic immobility in particular, it would be really hard to misread the point at which somebody is physically incapable of engaging in the act that you're engaging in. They literally are unable to move their body on their own. And so, especially with collapsed immobility, although their eyes may be open or, you know, they may be semi-conscious, they are unable to action their body. So,
Well, but
for somebody,
couldn't there be a range of freeze reactions? And you might have somebody who was more or less immobilized, but capable of some small physical response.
there can be a range and there can be a going in and out of.
Mhm.
But tonic immobility itself does not look like, it doesn't, I'm trying to word this the right way. It is not an act of submission. It's an act of protection. And I am trying to imagine a case where somebody was engaging in sexual conduct with somebody who was not able to realize that they are not in control of their body or their speech.
Well, I guess what I'm going to is it seems in this rendering in the bill we're looking at, it seems to me that the drafting and the thinking about what isn't consent has been considerable.
Right.
It seems a little underdone on what constitutes consent. And that's, of course, the pivot point that people will be prosecuted on.
Right.
So, you know, any suggestions for how we might beef up that language? We had our attorney send us around some other definitions of consent from other states, but
Yep.
that's my question at this point.
Yeah. And again, you know, it's not entirely in my wheelhouse to be thinking about it in those ways. My, you know, certainly my goal today was to kind of open up the conversation about when the bill talks about incapacity or impairment, that looks like more than, you know, being intoxicated or having substance use be occurring in the act. So I certainly would like to hear from other witnesses, and also we'll think about ways that would make sense and can come back to the committee.
Great, thank you.
Yes, I very much appreciate the discussion. I think obviously if there's verbal consent, then that's fairly easy. Or if there is not verbal consent, it's also fairly, if somebody verbally says no, that's easy to understand. But if somebody is unable to engage in, I like that term, is unconscious, so intoxicated they're unable to engage in it. I'm not sure at what stage of intoxication, you know, you're rendered incapable of deciding. So, you know, I think there's a lot of thought needs to be taken into this. And that's one of the reasons I liked having something in there regarding the totality of the circumstances.
Right.
So that you're taking into account everything that's going on. And that's not in the House draft. It's, I believe, in the federal statute. Senator White.
So thanks, Kate. That was helpful. And I'm sorry to have been late, but again, at the risk, as Joe said, of putting myself in the hot spot here, I do have the same concern of the nonverbal assent, that there is consent non-verbally, and I am concerned, and I hope that we can come up with some language that that clarifies that, so that just because there isn't verbal consent, it means no consent. And so I do have that same. I think it's pretty clear if somebody is incapable of moving or incapable of engaging, that's pretty clear in my mind, but it's a different level that I'm concerned about. And so I hope we can come up with some language that doesn't mean that just because there isn't verbal consent, it's non-consent.
Is there anybody I already had questions for Kate first. Is there anybody else in the room with us who would like to comment on the discussion? At this point, either Sarah, Rebecca, David, Rory, or Michelle. Rory?
Well, I'll let Michelle go first if you'd like.
Okay. Yeah, you both.
I was just going to mention something with respect to Senator Benning's concern about a sleeping partner. And so the act requires as an element that a sexual act, the statute does. And so that sexual act is specifically defined, and I'm going to put that in the chat so you can look at that and send it out to everybody. So the definition of the sexual act. And so I would imagine that in the scenario that you're talking about, Joe, that, you know, you kind of turn to your partner and whatever, they're not necessarily while they're still asleep going directly to what is defined as a sexual act. There's a little bit of a lead up, or there's something that then rouses the person, and then the actor is able to engage the person's interest or willingness to engage in the sexual act. But that the actor wouldn't be engaging in the sexual act while the person is still asleep and unaware that the sexual act is occurring.
Michelle, any intrusion, however slight, of the parts listed, I don't want to get too personal here, but the long and the short of it is people commence sexual activity in many different ways. I know that this bill is trying to get at preventing someone who either doesn't want it or is manipulated by the perpetrator to stop that kind of behavior. But it seems to me there's a strong possibility that the sleeping person may have been invaded in one of these categories in the hopes by the other person that when they wake up, they're going to continue the activity. And that's where I get a little queasy on moving that particular portion.
Well, yeah, I think the act clearly does say you don't intrude into a person's body unless you know you have consent.
And so you have a sleeping partner, and this may have been activity that was in previous engagements perfectly acceptable.
That doesn't matter under the rape shield law.
I know. So now you're specifically saying to all couples in this situation, you cannot move to go into one of these categories if your partner is asleep. There's no ands, if, buts, or maybes about it. It's a very clear statement. We're creating a potential criminal case if you do. And that has me leery about how people normally interact with each other. I fully understand and support the concept of preventing activities by people who are either manipulated into when they don't want it, or they are unconscious or rendered under some kind of duress. I fully understand and support that concept. I want to be very careful that we are not including something that was unintended. And as I see it written the way it is currently, I have that fear very deep. So I'm.
Can I ask Joe a
I don't know where
question?
to go. Yeah.
So
Yeah,
Joe, in that case, nobody's going to know about it unless the partner files some kind of charge. I mean, so if the partner files some kind of a charge, then maybe there's issues there that go beyond just a nice, healthy relationship. And I
can't deny that, but we are setting up initially a charge. And if the partner wakes up and says, okay, that's great, you're right. No reports made. We're done with the conversation. But if for whatever reason, and I've represented people in family court for 37 years, and I know there are instances where people suddenly have a change of heart. We have now created a criminal offense that I'm not sure we want to go in that direction with. But I'm open to hearing other conversations from lawyers.
I'm good. And right now, I've got Rebecca Turner, who's got her hand up, and Rory, who was going to speak, and I'd like to hear from both of them, and then we can continue the conversation. So starting with Rory and then Rebecca.
Good morning. For the record, Rory Tebow, Washington County State's Attorney. I think it's important to go back to the existing law and definition of consent, which is consent means words or actions by a person indicating a voluntary agreement to engage in a sexual act. So under existing law, a sleeping person cannot demonstrate through either words or actions that they're voluntarily engaging in that. Again, I agree with Senator White's assessment, which is past actions or pattern of conduct may suggest that that's okay in the confines of an established relationship. And again, if there is a complaint, it's not, there aren't SIU detectives in everybody's bedroom or camera monitors. When we deal with or address a complaint like this, it's because one partner or the other has come forward with those circumstances. Even then, I think Sarah Robinson in the past has provided great testimony about the number of reports versus the number of cases filed versus the number that actually proceed to a trial. I think what you're taking out of the loop here is prosecutorial discretion, which includes necessarily analysis of potential mistake of fact as to consent. These are all factors that get considered before going forward. And I don't want to be the whiny prosecutor, but we are resource limited. We do not have the luxury of pursuing complex sex assault cases on fringe theories where we stand very little chance of succeeding at trial. Unfortunately, I think to the detriment of victims, there are times where tough calls fall on the side of not filing because there's such a low likelihood of succeeding at trial, leaving them to really seek civil remedies or other recourse to protect themselves. So I think that, I don't mean to be too dark with this, but the scenario in which is being discussed is incredibly limited. And under existing law, that person, if sleeping and penetrated, there is a potential prima facie case. The modifications proposed by H183 tend to clarify the state of the law, but they don't cover any new ground with respect to the propriety of engaging in a sexual act with someone who's sleeping or unconscious. Last point I'd like to make as well, though, I think Senator Sears' point is very well taken about the totality of the circumstances. While it does not appear in either the federal draft or in H-183, it does seem appropriate that the consent definition in section 1 be concluded with a comma based upon the totality of the circumstances. But with that being said, there are some circumstances that either fall into the rape myths, as we previously discussed, that are currently under the trial procedure, or rape shield evidence, which is precluded. Absent that, the totality of the circumstances is always considered, not just by the fact finder at trial, but by the prosecutors and investigators who are looking into these cases in the first place. We absolutely take into account what the nature of the relationship was, what the history was, what the past experiences were. And the rape shield is not a full shield, if you will. Rather, there are some constitutionally based offenses or circumstances, particularly when relating to a mistake of fact, that can come in. So with that being said, I believe that there is not new ground being covered, and the discussion here is, I think, more academic than how things are practiced.
Well, Rory, clearing my hurdle, I'd feel a lot more comfortable with the phrase totality of circumstances being plugged into the mix.
Thank you.
I think that's completely reasonable.
Rebecca?
For the record, Rebecca Turner from the Appellate Division, Office of the Defender General. Good morning.
Morning.
I want to jump off of where Senator Benning's concerns are, specifically with this sleeping or unconscious person cannot consent language, and then step back a little bit. But I agree with his interpretation that as proposed now, that presents as an absolute no consent scenario that doesn't take into account the moments before the sleep in terms of whether or not the partner, the sleeping partner, consents affirmatively, even expressly, as Senator Bruce was trying to tease out, in terms of we still don't quite know what it takes to satisfy consent under this. But let's even assume we have affirmative, clear, unequivocal yes to sexual activity while I'm asleep. Under this statute, and let's add that this is a long-term relationship, married or not, loving, and that this is also something that is done, is something that is practiced. That under this statute, it's an absolute cannot consent. And so Senator Benning's concerns are warranted. I also wanted to point this committee to existing law on this question. The Vermont Supreme Court was presented with a challenge conviction of sexual assault involving a sleeping complainant. And the Supreme Court ultimately affirmed that sexual assault conviction. And in that analysis, interpreting current law on consent and the requirement of compelled conduct, the Supreme Court took note that there was no indication before sleeping that the complainant consented. Again, and of course, the Supreme Court also noted that, of course, a sleeping complainant cannot consent, as sort of an obvious sort of truism, that if you're asleep, you can't affirmatively, and again, this is back to the affirmative yes consent, right? But the point of the Supreme Court's decision, and that is State v. Snow, 2013 VT 19, was that consistent with what is discussed here, which is considering the totality of the circumstances, including before sleeping, that goes into the analysis of whether or not there was consent and whether or not the charged person, the defendant, knows that there was consent. All pieces to the puzzle explored by our Vermont Supreme Court. So there is case law. The statute departs from that significantly and creates that absolute liability. To Rory Attorney Tebow's point that we should take comfort in the prosecutorial discretion to only prosecute offenses where the attorneys involved, law enforcement involved has done considerable investigation, trust them to exercise their discretion and judgment as to what is a crime. Now, with all due respect to Attorney Tebow, and I've discussed this before, that is not how we assess the constitutionality of laws that cover otherwise innocent conduct. I also want to make sure, and I know that we've talked about, and I still haven't heard an answer as to what is lawful consent. Because even if there is an affirmative, clear yes beforehand, at what point must that continue, right? To what extent? But I understand, and I see Michelle Childs has pulled up the comparison of the consent laws to what is referenced, has been referenced to federal law, but let's be clear, that is a reference to military law, not federal criminal law that applies to civilian courts, but military law that only applies to military courts. And I think that.
But I think it's important to note that H 183, when drafted in the House, in my understanding, they followed the military federal law, and so that's why it's there. I don't think there was that's what the House did. So.
Thanks.
I would just add that they did, and they looked at the other one, but the Title 18 federal law has not been amended since the early to mid 80s, and the military has been updated recently. So they were looking at using Title 10 because it had a fresh look rather than being 40 years old, is why I did that.
But go ahead, Rebecca.
Oh, excuse me, and Michelle, I don't question that, and I'll take that in terms of the most recent amendment. What I wanted to just highlight in terms of stressing why it's significant that this law is being pulled from military law and not civilian law is that military law is fundamentally different from law that is developed in the civilian courts. Fundamentally different because of the underlying purposes served by military law, and I'm extending that to definitions of crimes.
Right.
And I know, and it may seem obvious to some that it's different, but I think that it's worth recognizing. I mean, we're talking about proceedings that operate in the court-martial context, where we don't have independent judges and jurors and peers, and that goes to a procedural side of things. But in terms of, again, the creation of crimes, the expansive creation of crimes, the motivation, reasons for that is because the military has an absolute interest in maintaining a disciplined force and the integrity of military forces. I was reviewing some of the academic journaling on sort of the fundamental differences and why they just don't cross pollinate between the two systems. But you know, one here describes it that commission of certain offenses in the military is seen as fundamentally destructive of military order and safety. And again, the emphasis there is not on individual rights and liberty interests, but on maintaining military order and control. And therefore, I think we have to be extraordinarily cautious when we are considering changing our own state's development of jurisprudence of sexual assault laws, pulling in from not just federal law, but military law. Again, where those definitions are broad. I was looking quickly at that specific military code that Michelle cited. I read it as Title 10 U.S.C. Section 920, not 910. There, where I was interested to see to what extent they eliminated the mens rea requirement, as this proposal does here, inserting knowing or reasonably should have known standard. I, upon my quick look, also saw that the military statute on sexual assault didn't go as far in terms of dropping mens rea. So I just wanted to alert the committee to
I
even that.
appreciate that. Would it be your testimony that this law is not needed?
Yes.
The current law protects these cases that this law seems to try to
Yes.
add. That current law regarding consent is adequate.
I think that the current law regarding consent is clearer than the proposed law here.
That, Rory, did you want to comment on that?
I want to respond to one thing. So I think as the last time I testified, I reminded the committee that I served for 8.5 years as a United States Army Judge Advocate in prosecuting and defending sex crime cases. I think Ms. Turner's assessment of the UCMJ, particularly with enumerated articles, is wrong. First, every United States military member is subject to the same constitutional protections as a civilian. While there are procedural differences in the system, the statutes are applied evenly. Reference to good order and discipline refers to only one part of the Uniform Code of Military Justice, specifically Article 134, which requires a showing of prejudice to good order and discipline or that discredits the service. Sex assault, murder, aggravated assault, all common law crimes that are codified under the UCMJ are treated commensurate with how state and federal law is treated. So that I don't think that's a correct assessment of how this applies. What I would also note is that parallel to what Vermont and other states have experienced, the military about 10, 15 years ago began a sexual assault crisis, much like what we see on college campuses today. A large number of young people in a kind of closed universe with a lot of alcohol available leads to some unfortunately dire circumstances and a lot of victims being created. It was in response to the national uproar and upheaval over the proliferation of sex assault in the military ranks that led to the United States Congress going back and revising these statutes. Additionally, I would note the UCMJ applies not just to uniformed service members, but also applies to U.S. individuals, whether contractors, State Department officials who are operating overseas or accompanying military members. That's the Military Justice Extraterritorial Jurisdictional Act. So that is applied to civilians as well. I would note that the reforms that we see in 10 U.S.C. 920 were bipartisan. Such individuals with a huge stake in the military, such as Senator McCain, Senator Gillibrand from New York, former Senator McCaskill, and others were instrumental in adopting these definitions upon consideration not only of the modern application of these statutes in states. Certainly, what has been proposed by the House does not go nearly as far as what some other states have done. Illinois, New Jersey, Colorado, for example. So I will respectfully disagree with Ms. Turner's assessment that we don't need this. We're relying on 40-year-old or more definitions. I think 1977 is what Michelle indicated the last time we took a fresh look at how to define consent. And again, I think we're in dire need of clarity and a standard, particularly when alcohol is involved and particularly when someone is incapacitated, as these are increasingly the types of cases that we see and are forced to reckon with in the court system.
Thank you. Michelle, with the little time we have left, perhaps you could go over the document that you provided, the comparison. I've got to pull it up again on my own device. It's a comparison between federal law and what H-183, and I compliment you on all the different colors.
Where is that?
It is on our where is it,
webpage?
Michelle? Yeah, I think she's going to pull it up. I think it's on our webpage.
Oh, there we
Can
go.
you see, you see it? I
see
emailed
it,
it. I emailed it to all of you yesterday.
Yeah.
So we should have it there, and if Peggy can post it.
It is posted.
See, the nice thing is we have green, yellow, blue, and purple. and hopefully there's.
So I was just trying to show to you how, when I was drafting, I was pulling the language from that. So I have to, I guess, correct that citation there. So you can see on the left, the federal definition in the military code. And you'll see there that it, not yellow, that it has an expression of lack of consent through words or conduct means there is no consent. And you'll see on the right-hand side there in H-183, that's in section 3254 on subdivision 2. Then the second one on lack of verbal or physical resistance does not constitute consent. You'll see is in subdivision 1 of 3254. Then the next one, submission resulting from the use of force, threat or force, or placing another person in fear does not constitute consent, which is subdivision 3 in 3254. And then the final one, a current or previous dating or social or sexual relationship by itself or the manner of dress does not constitute consent. And then we have the reference to that provision in current law. So then on Division 7B in the federal, you'll see a sleeping, unconscious, or incompetent person cannot consent, and that's in subdivision 5 on 3254. I think the language that's also in B is already in with regard to the force provisions under the existing law that we didn't change. The one thing, as Senator Sears mentioned, and I think Joe said he was interested in, is that I didn't pull in there was subdivision 7C there, that all the surrounding circumstances are to be considered and whether a person gave consent, which would be the case whether you had that language or not. But I certainly understand that just having it there in the statute may provide folks with some greater comfort about that. So moving down to the definitions of incapable of consenting. So you'll see on the federal level on the left there, it's incapable of appraising the nature of the conduct at issue. And then in the House version, it's incapable of understanding the nature of the conduct at issue. I did have the same exact language with appraising. And after hearing from various witnesses, they decided to use the word understanding instead. You'll see that on the let's see.
Unwillingness.
Right, so then you see an 8B, physically incapable. Right now you have in current law, which, so we're just redoing that, is not physically capable of resisting. And then the rest in the 10B is the same as existing law in Vermont. And then you'll see on the last one on 10C, lacks the mental ability to make or communicate a decision about whether to engage in the conduct at issue. And that's just a reworking of current law that you have on the books that says the person is mentally incapable of understanding the nature of the act. And then another provision that says the person is mentally incapable of resisting or declining consent. And so that's something that we worked through with some of the mental health law advocates that were testifying in the House.
Thank you.
Mm-hmm.
Thank you
Can I ask a
very much.
question?
Sure.
So Michelle, would you go back up to the yellow? So
Okay.
if I leave out words and say an expression of lack of consent through conduct means there is no consent. So that's said in a negative way, but if I read it, it says conduct that implies consent is consent. Is that?
I think it's saying that if you, through your conduct, so like in Joe's scenario, my partner starts loving me up in bed, and I push his hand away, or, just kind of roll back over or something like that. That's an expression of lack of consent.
Right. But I'm trying to put it the other way. So by my conduct, I can consent.
Sure, because if when they do
Right.
this, instead of pushing the person away, you open your arms.
Right.
Turn towards the person, or you start to engage, then you're not saying anything, but now that
Right.
they express their interest, you turn to them, and if
Right.
you're
So my conduct is
Right.
giving consent.
your conduct is giving consent because you're choosing to engage in
So
this.
I don't have to say, I don't have to say yes,
Right,
but I can through conduct. Okay,
Think-
correct.
that helps.
I think I've got Michelle, I really appreciate this, and everyone who's been here. Unfortunately, it is now 11:24 and we're due on the floor at 11:30.
Oh,
So I've got to cut this short. But I appreciate everyone being here, and hopefully we can take this up again. Peggy, can we fit it in next Friday?
Yes, we can, 9 o'clock.
I thought, yeah, well, look at your agenda, whatever.
Yeah. Yeah, 9 o'clock,
yeah.
we can do it for a half an hour.
That
I've got to
would
go.
be
Senator.
overly ambitious. Oh, go ahead. We can go offline. You and I
Okay,
can
hold on.
talk about the agenda, Peggy.
Okay, hold on one second.
See you on the floor.
See you all on the floor.
okay. Hi.
And thank all the witnesses.
Can
Appreciate it.
Michelle,
thank
you stop sharing so I can get to